If you have a workers' compensation claim or L&I claim in Washington state, you might receive vocational services. These services are a pretty complicated benefit under the Industrial Insurance Act. That's because some benefits are a matter of right under the Act, vocational benefits are discretionary. This means that injured workers receive vocational benefits only if the L&I director grants them. Interestingly, the Department of Labor and Industries conducted several studies. They show that when vocational services are provided early, work injury claimants return to work faster. Therefore, the current trend is for vocational assessment services to begin early in your L&I claim. The vocation assessment is performed by vocational counselors, they do not work for L&I. However, they are obligated to follow L&I rules and guidelines as they work through the vocational aspects. When they do the assessment, they have to adhere to certain priorities to help workers return to work. 1. They first assess if the worker is capable of returning to work at the job of injury with the same employer. Sometimes, the job of injury is no longer available, but the injured worker is capable of performing the same job. In such cases, vocational counselors look to the labor market to see if the job is available with another employer. 2. The second priority is when the injured worker cannot return to the job of injury. Here, the vocational counselor determines if the worker can perform a different job with the employer of injury. If not, the vocational counselor looks at the skill set of the injured worker. Then, the vocational counselor determines if the injured worker possesses transferable skills to work on another job in the labor market that is within the abilities of the work injury claimant. 3. The third priority is when the injured worker cannot return to the job of injury and lacks transferable skills. In such instances, the vocational counselor explores whether the injured worker can be retrained. In order to recommend retraining to L&I, the vocational counselor must believe that the injured worker can be retrained over a 2-year period, and that the retraining will make the work injury claimant employable in their labor market. If the vocational counselor believes that retraining is worthwhile, they will recommend that L&I approves a retraining plan development. Once the Department of Labor and Industries approves the plan development, the vocational counselor will more formally assess the injured worker. This time, to determine the injured worker capabilities and interests for retraining. At this phase, I believe it is critical for injured workers to be invested and engaged. If a vocational counselor believes that retraining is a viable option, they must make the recommendation to L&I. This happens whether the injured worker is interested in the retraining goal or not. Therefore, injured workers should advocate for a retraining goal that is satisfying and fulfilling to them. At the end of the day, L&I is not obligated to return the worker to a job where they earn as much as before. This is often a source of frustration for many injured workers during the vocational process. Furthermore, the retraining plan can take up to 2 years. The injured worker should receive time loss compensation while undergoing retraining. If you feel that your vocational counselor is not performing the job that they should, or that they are interfering with other aspects of your L&I claim or self-insured employer claim, please don't hesitate to give our office a call for free consultation.